Hello, and welcome to the second of our pick and mix sessions for today. We've got sessions running throughout the day from black letter law to practical matters. Today's is a practical one. It's to do with mediation. It's being led by Nigel Clayton, who is a senior junior in the property team. He's a civil recorder. And many of you will know that he has his own website, www.legalmortgage.co.uk. I'm quite sure what that is about. Nigel is also a mediator, and that's what he's going to talk to us about today. So over to you, Nigel.
All right, thanks very much, Geraint. Good morning, everyone. All right, mediation. This is quite timely, I guess, in many ways. There's been a lot in the headlines, certainly over the last year, about mediation. And some of you may have seen the Business and Property Court Forum, the Manchester Business and Property Court Forum last night. A great presentation about the future of ADR and about mediation in particular. So I'll make some comments about that, but it's quite a timely occasion, really, to be talking about mediation. Of course, we all love mediations. Just see if I can get my second picture. Yes, there you go. We all love that occasion when we sit around the mediation table, waiting for something to happen. Incidentally, if you're only listening to this webinar, you will miss some of these fantastically amusing cartoons. But let's get on with some of the content. What are we going to be talking about? Four sections, I suppose. I'm going to begin with, I think, an important update on where we are up to with mediation. As I've said, there's been quite a bit in the headlines about this recently. I just want to give you a few snippets, a few quotes that really highlight the where we're going with this. Some things to think about, some of my own comments, and then some do's and don'ts. And I'll try and wrap up at the end with some comments about the future of mediation, where I think it's going, and the form and style of mediations for the future. Incidentally, I'm not particularly inviting Q&As. I'm not sure we're going to have a great deal of time by the end, but incidentally, I do have one question for you halfway through. So let's just see if you can spot that. But let's get on. Where are we up to with mediation at the moment? Well, I'm going to give a few headlines, and these are in date order from this year. Geoffrey Voss, first of all, Master of the Rolls. This is an announcement that hit the headlines on the judicial website fairly recently, but it was in fact a speech he gave to Hull University's Mediation Centre on the 26th of March this year. And the quote is, you can read it for yourself, there is perhaps a linguistic problem. Why do we keep on talking about alternative dispute resolution? Dispute resolution should be an integrated whole. Mediated interventions should be part and parcel of the process of resolving disputes wherever they arise in our society, whether between businesses and consumers, amongst families, or between the citizen and the state. There is nothing alternative about either mediation, early neutral evaluation, or judge-led resolution. What I hope to achieve is to take the alternative out of ADR, a widely quoted speech. That seems to have then coincided with the report of the Civil Justice Council in the middle of the year, June 21, reviewing the legality more than anything else of compulsory ADR. And I think this was particularly in the context of steps by the Ministry of Justice to introduce formal compulsory ADR schemes. And the issue in particular was whether it was in breach of Article 6. There's a lot of detail in this report. You've got the link below. I think it runs to about 58 odd pages, led by a Court of Appeal judge. But the particular comment I've highlighted, if ADR is no longer alternative or external to civil justice, then parties can surely be compelled to participate in ADR as readily as they can be compelled to disclose documents or explain their cases. The sanction for failure to participate may be to prevent the claim or defence continuing, either by making the commencement of proceedings conditional on entering ADR, or empowering the court to strike out a claim defence if a party fails to comply with a compulsory ADR order at a later stage in the proceedings. So You can see where this is going. The upshot, the conclusion was that it did largely pave the way, certainly legally, to the introduction of compulsory ADR, at least where cost benefit justified it. So the move now, I think, is to look to introduce compulsory ADR where schemes are cost effective. They can be achieved at modest and proportionate cost. There was then, of course, the Ministry of Justice call for evidence to review dispute resolution generally in England and Wales. This is a call made on the 3rd of August. The consultation has just closed, actually. And again, it comments about what have been regarded as alternative methods of dispute resolution. In particular, you'll see the middle of the page, for far too long, the so-called alternative approaches to court have been seen as an add-on or diversion for people seeking to resolve a dispute. Our ambition is to mainstream non-adversarial dispute resolution mechanisms so that resolving disagreements proactively and constructively becomes the norm. And then the final quote, again, Sir Geoffrey Voss, Master of the Rolls, in October of this year, 28th of October, again, talking about his views on mediation in court systems. He says, since I became Master of the Rolls and Head of Civil Justice in England and Wales in January 21, I've been sounding off on this subject quite a bit. Indeed, in some ways, I've been doing so too successfully. Since I pointed out that alternative dispute resolution was in no sense alternative, but should be a mainstream part of the dispute resolution process, some ministers in the UK's Ministry of Justice have refused to use the term ADR, moving more accurately, in my view, to the term DR. So those are the quotes. You'll see from those where things are going. And I just flag up finally in terms of seeing where mediation fits in. You may or may not have heard that the HMCTS, Courts and Tribunals Service, has launched what's called the Possession Reform Project. Just launched just a couple of weeks ago. And the quote is that possession proceedings in the civil courts are generally issued to solve a dispute that has arisen between a landlord or lender and a tenant. This could be for reasons such as rent or mortgage arrears, antisocial behaviour, or other breach of tenancy. The Possession Reform Project is due to commence early in 2022 and will automate and streamline the possession process from start to finish. I know that I think Nick Taylor and Ian Cooper might be mentioning this in their talk later on at 4 o'clock. The mediation pilot, funded jointly by the Ministry of Justice and the Ministry of Housing for Communities Local Government, was conducted between February and October 2021. We will evaluate the service and use the findings to help to decide how mediation can help in the future as a method of dispute resolution. So, again, as I've said, you get a flavour from those comments about the way things are going, particularly this year, and the sort of resurgence, the groundswell of certainly judicial support for forms of ADR, forms of mediation, even compulsory forms of ADR. But let me just pause and just go back to one of those headlines, and I'm going to get you to start putting your thinking caps on. For far too long, the so-called alternative approaches to court have been seen as an add-on or diversion for people seeking to resolve a dispute. Let's just think about that. Before you do, of course, there are all sorts of alternative methods of dispute resolution. I'm not sure if your firm has ever engaged in this. But as I say, let's just go back to that quote. For far too long, so-called alternative approaches have been seen as an add-on or diversion for people seeking to resolve a dispute. Let's just ask 3 questions. To be frank, how many of you still see mediation as an optional extra? How many of you regard the cost of mediation as an additional and often unnecessary cost? And how many of you have come up with a reason to avoid mediation? If the answer to any of those questions is yes, I think you may need to start reconsidering your approach to mediation. And in view of what I've been saying about the move towards the introduction of compulsory ADR, I think you're going to have to. So let's move on. Some other things to think about. The obvious one, and I've heard this time and time again, some disputes aren't suitable for mediation, right? Well, wrong. There may be, as I said, any number of reasons why you might prefer not to mediate. And I've listed the obvious points that I keep hearing. Parties have a strong case and a winnable and a losable case. Points of law involved that are better suited for determination by a judge. Difficult issues, difficult clients who may not even want to engage in mediation and sit around the table with an adversary. Generating fee income. Why cut the legal service early when you can carry on running it to trial? So there's any number of reasons why you might think that you might not want to mediate. But as I said, I suspect there are very few disputes that can't be mediated. And my question is, in the context of property law in particular, which is my practice, can you think of any? If you can, put them on the chat or the Q&A at the bottom. I'll come back to them at the end. I personally think that all disputes are capable of resolution one way or the other. Incidentally, I don't think this is in the mediator's handbook, but to be honest, we've all wanted a Maxwell as a mediator from time to time. Again, if you're listening on audio only, you'll miss that fantastic sketch. Another point to think about, we all hear about the cost consequences of a failure to engage in ADR. And we all, I know practitioners, have this anecdotal sense that, yes, there will be consequences somewhere down the line. But what are they? Well, I think it's a good question. I think the answer has certainly largely got lost in the midst of time. I've tried to list here some of the key points. CPR 44.2, of course, the general discretion on costs. The general rule is that the unsuccessful party will be ordered to pay the cost of a successful party. The court may make a different order having regard to conduct. You may be familiar with the leading court of appeal authority on the significance of ADR having regard to the cost consequences. That's Halsey, Milton Keynes General NHS Trust, 2004 decision. I think it was Lord Justice Dyson. Whether a successful defendant should be deprived of costs because of a failure to mediate. And you may recall the Court of Appeal there gave some guidance about the factors to take into account in deciding whether a refusal to agree to ADR is unreasonable. I've just lifted out the weekly law reports, and I can list those factors as follows: the nature of the dispute, the merits of the case, other settlement methods have been attempted, the costs of mediation will be disproportionately high, delay, or finally, and this is a point that is frequently referred to by judges when dealing with the cost consequences, whether the mediation had a reasonable prospect of success. Halsey, I know cases have moved on since then, and there has been some, to a greater or lesser extent, judicial criticism of some of the things that Lord Justice Dyson said, but it still stands the test of time, and those guidelines are still being referred to. A more recent decision, PGF2 and OFS, is, I think, a decision of the then Lord Justice Briggs Court of Appeal decision. This addressed a slightly different issue, whether the failure to respond at all to an invitation to participate in ADR is unreasonable, regardless of whether there might have been reasonable grounds for refusal. And the upshot of that, and the passage from Lord Justice Briggs, he says at paragraph 56, this case sends out an important message to civil litigants, requiring them to engage with a serious invitation to participate in ADR, even if they have reasons which might justify a refusal, or the undertaking of some other form of ADR, or ADR at some other time in the litigation. So Again, striking a word of caution about your decision to decline an invitation for ADR or even not to respond at all. So just moving on with those cost consequences. Again, I've noted here the general practice direction on pre-action conducts and protocols. There are quite a few points, a few paragraphs here which are relevant. Again, middle bullet point, a party's silence in response to an invitation to participate might be considered unreasonable, could lead the court to ordering that party to pay additional court costs. Again, paragraph 14C, the court may decide there's been a failure of compliance when a party has unreasonably refused to use a form of ADR or failed to respond at all. And then significantly, the particular cost sanctions the court can impose in paragraph 16 order the party at fault to pay all or part of the other party's costs, order the party at fault to pay costs on an indemnity basis. If the party at fault is a claimant who's been awarded a sum of money, an order depriving that party of interest or awarding interest at a lower rate, or if the party is at fault, if the party at fault is a defendant and the claimant has been awarded a sum of money, an order awarding interest on that sum for a specified period at a higher rate. So specific cost consequences there of a failure to engage in ADR. Incidentally, if you listen to the Manchester Business and Property Court Forum session last night, I think it was His Honour Judge Stephen Davis who particularly tried to flag up what the court could do to sort of encourage or coax parties towards ADR, and again, warning of the likely cost consequences of failure to do so. I'm going to mention a couple of cases about the specific cost consequences. There are actually quite a few cases when you start trawling through, but picked out one, a decision of our colleague, our former colleague in the business and property team here at King's, Mark Halliwell, Wales and CBRE Managed Services, a 2020 decision. Mr. Wales's claim against CBRE for damages for breach of service contract was dismissed, but CBR had acted unreasonably in failing to respond to and then refusing to participate in mediation in the week commencing 17th of June 2019. Now, the transcript shows Mark's approach to this and the structured way in which he addressed CPR 44.2, the Holzer decision and PGF. And the decision he made was to disallow 20% of CBRE's costs from the 17th of June. And just flagging up the point that I flagged up in Halsey, the final guideline, whether the mediation had a reasonable prospect of success, Mark said this: in the hands of a skillful mediator, there is a reasonable prospect that common ground could have been found on at least some of the issues, and indeed that a wider basis could have been found for compromising litigation as a whole. So party there, defendant successful, but still disallowed some of its costs because of a failure to engage. And a slightly different point now, I just thought I'd flag this up so you're aware of it. Reed and Buckinghamshire Healthcare NHS Trust, it's an unreported decision, I think from 2015, a senior cost judge in London. He's recognised that the majority of reported cases involve penalties imposed on successful parties, in other words, winners. But what about losers? Well, of course, losers normally get hammered with a costs order anyway, but of course, it gets worse if they've also refused a reasonable offer of mediation. And the judge there said if the party unwilling to mediate is the losing party, the normal sanction is in order to pay the winner's costs on the indemnity basis. That means they'll have to pay their opponent's costs, even if those costs are not proportionate to what was at stake. And this penalty is imposed because the court wants to show its disapproval of their conduct. So an order for indemnity costs from the date of receiving the offer to mediate. So I hope that helps to flag up a few of the specific cost consequences, which, as I say, tend to get lost in the mist of litigation. So what points do we take for that? Well, some do's and don'ts here, and particularly following on from the cost consequences. Obviously, do not ignore a request to participate in ADR. And if you are going to refuse ADR, make sure you've got reasonable grounds. Put together a structured response. And bear in mind, the request for ADR and your response will almost certainly be referred to when the court comes to consider the question of costs at the end. So it is important. Do respond promptly, don't delay, because that may have an impact on not just timing, but the interest of an award that may be recovered. And of course, consequentially, do make sure you fully explain those cost consequences and risks to your client. If it's your client who's digging in, make sure they're aware of the risks that they're running. Some more do's and don'ts. This is a bit of a personal dig from me, both as an advocate, as a negotiator, and now as a mediator. The mediation bundle is not a trial bundle. It's not a test of how much you can pack in there. Believe me, the mediator is not going to read it. And equally, a position statement is not a skeleton argument. It does need to concentrate on solutions, not legal arguments. And I think a useful discipline is if you can't get it down on, say, 1 or 2 sheets of paper, then you're possibly missing the plot, really. So less is always best. Of course, sometimes, according to this, you just need to get on with solutions. Again, we've all wanted a Thomas Tiny Tominski to mediate some of our disputes. I'm sure I've seen this chap. I'm sure I've sat around the table with a guy who looks just like that. Okay, again, do's and don'ts, conduct of the mediation itself. This now gets into the process of mediation, and it's something that I've been particularly alert to sort of learning about on my ADR Group training course. Do prepare your client. Far too often, we just end up at mediation with no prior meeting, no discussion of issues, and no preparation. Paul Johnson, I think, very skillfully flagged this up last night at the Manchester BPC Forum. And he particularly emphasised the psychology of compromise and how you do prepare your client. He referred to 4 phases: the introductory phase, the exploratory phase, the negotiation phase, and the concluding phase. And he says, far too often, the advocates, the negotiators, want to get straight to the negotiating phase and get things on the table, but they miss the importance of the introductory phase and the exploratory phase. And he said, and I think he's right, if you go straight to the negotiation phase, you sometimes have to stop and go back again. You have to introduce your client to this process and get them to buy in to the psychology of mediation. I think you need to discuss with your client the process of escalation and de-escalation. Any dispute has various stages. You may have differences, disagreements, problems, disputes, conflict, and then violence. Wherever there is a process of escalation, there is a process of de-escalation. I think you need to try and identify that with your client and see what your options are. You may have heard of the expressions BATNA and WATNA, the best alternative to a negotiated agreement, the worst alternative to a negotiated agreement. So again, weigh with your client beforehand what those options are. What are the likely outcomes? What are the best options, the worst options? And of course, weigh into that cost benefit as well. My sense is that in far too many mediations, and this is sometimes a fault of the mediator, the parties tend to dwell on weighing on cost benefit, with the mediator making the point that it's going to cost them a fortune to go to trial. They should look for a solution they can live with, albeit it's one they might not be particularly happy with. Not sure, frankly, that's an entirely helpful approach. So do manage the whole mediation process from before mediation through the mediation itself. Anticipate the form of settlement. Again, do bear in mind that for property disputes, particularly where there is any prospect of a settlement involving a transfer of an interest in land, in order to have a contract, a binding contract, you need that to be in writing and signed by the parties, Section 2 Law Property Miscellaneous Provisions Act. I know that it's always a useful discipline to come away from any mediation with a signed, at least heads of agreement, but for property disputes in particular, it is a cardinal rule, get it signed off there and then. I have unfortunately had experience of mediations going off and the parties simply not wanting to sign up what in principle they'd agreed to. A final plea from me on this, don't go on late, for goodness sake. You may all have heard these anecdotal stories about, being at chambers well after midnight and sending out for pizza and beer. Believe me, that's not funny. That's when things have gone wrong. If you go on after 6 p.m., certainly after 8 p.m., you're in what I call the danger zone. It's when parties get tired. It's when they become a little irrational, if they haven't been already. It's when they start making mistakes. It's when you as the negotiator start making mistakes. And it's when the mediator starts making mistakes too. Frankly, I see no real reason to thrash out difficult issues so late in the day when you're going to make mistakes. Adjourn and carry on the next day. Okay, there'll be more costs, but it's a safer process. Sorry, a bit of a personal plea there from me. So let's move on into another section, some quotes that will lead us into the future of mediation. I've got 3 quotes here. There are no right ways or wrong ways to conduct mediation as a means of achieving alternative dispute resolution. The way we've done things in the past isn't necessarily a good guide as to how we should do them in the future. And if you're going to pay for a decent property lawyer to mediate your property dispute, why not use his property law expertise? I've chosen those quotes on purpose so that you can see where I think the future of mediation may lie. And this leads us into this interesting issue about facilitative mediation and evaluative mediation. I was listening out with intent last night at the Manchester BPC Forum to see if anything was going to be said about this. And it cropped up right at the end when somebody raised a question about how the panel viewed evaluative mediation, but it was largely lost. It was never really discussed. And I think, in fairness to him, I think Paul Johnson towards the end just brought it back a bit by saying, well, to a greater or lesser extent, all mediators have to evaluate issues as part of the process of facilitated mediation. That's fine. That's not what I had in mind here. Facilitated mediation is what we call the traditional method of instructing a mediator, a third party, to facilitate negotiation and settlement. Like any mediation, it's a non-binding process. The mediator doesn't advise either side, and he doesn't generally offer an opinion on the law or merits. He may privately place pressure on the parties and emphasize strengths or weaknesses, but is not there to advise on or make decisions on the law. And I've rather tentatively put at the bottom there that, quote, any mediator will do. I'm not going to get started on the quality of mediators at this stage. I've seen a whole mixed bag in my time, I'm sure you have. But evaluative mediation, this enables the mediator to offer a view on the law or merits as part of the process of facilitating settlement. Yes, it's still a non-binding process, and to a large extent, you do need to prepare your client for this, to buy into the process, so that they know there's going to be some sort of evaluation and some indication of merits being expressed. I think it follows from that, but invariably, it probably does require a greater degree of flexibility. And I think finally, you do need a mediator who knows what he's doing. So the view is that if you're going to have an evaluation on a property dispute, you need a property lawyer who knows what the issues are and who knows what the law and practice is. I think some of the points that arise out of that then, if you weigh up facilitative mediation against evaluative mediation, I think I'd make these points. Do be constructive and not constrained. As I said in one of the quotes earlier, the way that you've mediated in the past isn't necessarily a guide to the way you should mediate in the future. And certainly with the way that compulsory mediations are likely to be imposed, you need to be a little bit more flexible about how you're going to solve a particular dispute. I think outside the box, but also I think set your own standards for property mediations. So what can you expect next? Well, bringing all these strands together, I think we are seeing a significant stepping up of ADR as part of the mainstream dispute resolution process. I think that's inevitable. I think it's clear from those earlier quotes that I've cited about the way the courts and tribunal service are going to seek to impose dispute resolution on parties. I suspect as well we're going to see some rule changes and some clearer cost consequences. As I said, I've tried to extract earlier on those relevant parts of the CPRs and the practice directions just to flag up what the issues and consequences are. But I think we're going to see some tightening up of those rules in consequence of the introduction of compulsory ADR. I think it follows that to a large extent, lawyers are going to need to quote up their game to keep on top of all this, and of course to get the best out of ADR. I think now is a good time, frankly, for practitioners to brush up on ADR generally and mediation, and to reflect on how you as a negotiator, as an advocate, want to manage mediations in the future. And finally, do be flexible with your approach. As I said, just because you've done mediations the same way in the past doesn't mean to say that's how you should do them in the future. Be flexible with your approach, but above all, make sure you do have an approach. All in all, if you follow all those guidelines, you can only expect happy and contented mediations with happy parties. What a great slide to leave you on. I'll leave you with that, with a note on happy mediating. Those are my details. If you need to contact me in chambers, I'm happy to discuss mediations, forms of mediations, or anything else. That's it from me, Geraint. Just out of interest, I am introducing the later talk at 4 o'clock, Nick Taylor and Ian Cooper on possessions, which should be interesting, actually, a booster dose on coronavirus in relation to possessions. But for me, at least, I hope that's okay on mediations.
Yeah, that's great. Thank you very much, Nigel. We've got one response to a point you raised earlier in the Q&A. Stuart Thomas has said that his view is that a reasonable excuse to decline to mediate or enter into ADR is going to be hard to formulate. He doesn't need an example. He doesn't have an example as such, but asks if you come across any case law where the court has been satisfied that a refusal to mediate was reasonable.
That's a really good question, Stuart. The short answer is no. All I can do is to flag up the importance in principle of formulating a reasonable excuse, having regard to the guidelines given in Halsey. Do have a look at those. 2004 One Weekly Law Reports, 3002. Those are the guidelines that are still being applied. I think the key is, whatever you do, don't not respond to a request for mediation or ADR. Do try your best to find a reason why you're not going to do it. But I think the point is, the way things are going, you're going to have to come up with a blooming good excuse to refuse ADR. And so I think, in view of the points I raised right at the beginning about the comments from not just the Master of the Rolls, but the various comments we're now seeing from Ministry of Justice and HMCTS, I think we're going to see get a better idea of the way that ADR and mediation is going to be imposed on the parties. So I expect you're going to get a much clearer idea of what you can and can't do, frankly. But yeah, good question, Stuart. The short answer is no, and good luck with it.
It always just seems to me that it's easier to say that the timing is wrong for mediation rather than mediation or ADR is wrong, full stop. I mean, some people I think use it to just put off and never engage in mediation. They say, well, timing's wrong. And you think, well, if not now, then when? But there are cases, if you have a particular need for disclosure, for example, before you can sensibly mediate or expert reports, then it's timing rather than an absolute refusal.
Yeah, I'll go to Leslie in a minute. I know she's just popped up, but just in response to that point, Geraint, Stephen Davis last night did make a very good point that he's never that receptive to people saying, well, they want, say, disclosure first, they want exchange of witness evidence first, they want expert evidence first. As you said, there's, frankly, properly analysed, there's never a good or optimum time to pitch into ADR. And the way things are going, the courts are going to be putting pressure on parties to do it earlier rather than some way down the line. I see Leslie's hand's gone up. Leslie, if you're there, do you have anything to add to that?
All I was going to add, Nigel, thank you for your talk. And I think I mediate as well and have done quite a few of them. I think on the question of what is not suitable for mediation, which was one of your early slides, it's often said that fraud cases are an example of a case where it's not appropriate to mediate. And I have to say, I disagree with that. In other words, it seems to me that they can be mediated, but that what you often have to take into account as mediator is that you need a mechanism to vindicate people's reputational interests as much as anything else. Because often the argument is that, well, he's accused me of fraud in open proceedings, and therefore, why would I mediate without there being some, withdrawal of that? But to my mind, it's not an answer to not mediate. It's a way. It's something you need to think about as to the ultimate outcome of it. So that was. I just wanted to add that because it was often said that that's the reason not to do it.
No, I think that's a good example, and it raises quite an acute sort of problem area. But if you think about it carefully, to a greater or lesser extent, all parties have a different sense of needing to be vindicated in the midst of a dispute. And that really comes down to the skill of the mediator to get people to psychologically review how this has escalated and how it can be de-escalated. So I think I stand by the point that I'm not aware of any dispute, frankly, particularly a property dispute, that can't be mediated. The knack is to mediate it and to find a way through, and sometimes it is difficult.
Great. Well, I think that's it in terms of the Q&A. So thank you very much for that, Nigel. For the rest of you, the next offering for the pick and mix is 11 o'clock. Mark Harper talking about expert evidence. So if you're going to be attending that, then I will see you then. Otherwise, thank you very much. Bye-bye.
Okay.